Appeals Court. She also practiced as an attorney at Public Citizen Litigation Group, a public interest law firm in Washington, D.C., where she focused on government transparency litigation. Professor Kwoka is a graduate of Brown University and Northeastern University School of Law and a former education volunteer for the Peace Corps in Burkina Faso. So with that, I will hand it over to Margaret. I think we will have her present her remarks, maybe follow that by question and answers, if that makes sense. And we're pretty informal, Margaret, so I think you can plan on taking questions along the way too. And then after we've concluded that, then I'll introduce Tom Sussman, our next panel.
That sounds great. Thanks so much for that introduction. And my apologies for being a few minutes delayed today. My son broke his leg a couple of weeks ago, and today he had a follow-up appointment that was supposed to take 15 minutes and took 2 hours. So, you know how these things go. So I appreciate your patience. I'm going to actually try to share just a few slides if I have permissions to do that. Is that right? Does that work? No, it doesn't work. Well,
I'm sorry to interrupt. Dr. Kwoka, Todd, do you have the permissions to do that?
You know, that's a good question. They don't come up when you set the meetings, but if I can find it now and offer it, I'm more than happy to. My apologies.
Oh, you know, I think unfortunately this is on my end because I have a Mac and it's now forcing me to change a permission that requires me to leave the app. I could skip the slides. That's fine too.
Margaret, if you'd like, if you wanted to email them to me quickly, I could also put them up and even move through them for you if you'd like, if it won't work for you.
That would be great. Where should I email them to?
Yeah, sorry. It's todd.albert@oregon.gov, todd.albert@oregon.gov.
Awesome. Okay, I will make that happen. I apologize for not having figured that out sooner. Microsoft Teams is not my usual platform.
Had this happen to me yesterday in a different platform, and someone else had to do my slides for me. So I think we all understand.
The world we all live in now, right? Here it is. I've just sent those to you, so when they get in, you can put them up at your convenience. But I really appreciate the invitation to be here today, and Steve for facilitating this, and all of you for giving me a few minutes to talk to you all about my research. As Steve said, I focus on the federal FOIA, though, you know, interact with state open records laws here and there, and certainly am very interested in some of the ways in which they diverge from each other, and fees is in fact one of those ways. And so I wanted to tell you a little bit about sort of like just things that you may well know, but sort of about the background of how fees work, both in theory and at practice at the federal level, and then also try to connect that a little bit to who ends up using FOIA, so who FOIA requesters are, which has been the focus of my research for quite some time, actually. In particular, trying to address the question that I think sometimes concerns people, which is that, you know, the idea that if we sort of drop fees too low or eliminate fees in certain categories, that might sort of provoke some people to use records requests as a form of harassment or abuse, or you know, sort of in some unreasonable or you know, harmful way. And so you know, interestingly, and I'll give you the sort of quick upshot and then I'll try to detail it, but interestingly, at the federal level, it's almost fair to say that practically no fees end up being charged. So it's a very free system. Most requesters pay nothing for various reasons. Across the board, including even commercial requesters, pay very little to nothing in the large majority of times. And individuals certainly pay almost nothing. Journalists almost never pay anything. And there are sort of fee structure reasons for that. But the truth is the federal government recoups a tiny fraction of what it spends on FOIA by charging fees. And so it's sort of a natural experiment. Like, does lowering fees to essentially zero, kind of provoke a huge abuse of the system? And what I found in my research is, and this is my quick upshot again, is that, by and large, no, it really doesn't provoke abuse of the system. Now, that isn't to say that the vast majority of requesters at the federal government level are who we might imagine them to be. So a lot of us, kind of in the world of FOIA, imagine FOIA is mostly used by journalists and nonprofits and watchdog groups. And the truth is, it's actually largely used for other purposes, but those other purposes are not purposes that I think most of us would characterize as some sort of abuse or harassment. They are legitimate individual and private interests that are being served, and in some ways, I think, unfortunately, through FOIA, because I think there are better options available, but it's not an abuse of the process. So let me detail a little bit about how that works. If my slides came through, I don't know if they did or not, but that'd be great. So I was just going to put up a few pieces of the federal statute. The first slide really just had the basic fee structure that the federal FOIA uses, which is sort of a 3-tiered structure. And those 3 tiers, here we go, perfect. Can you flip one ahead? Thanks. So those 3 tiers are commercial use, which is, folks who are using FOIA for commercial purposes are supposed to be charged the largest amount of fees, and that's done by what kinds of work can be charged for. So search time, duplication costs, and review time. Review time being reviewing records for necessary redactions or withholdings. So that's sort of the full universe of costs that could be charged. And the idea is that commercial requesters will sort of pay their way, right? That they'll foot the bill for their use of the law. The second category is fees limited to duplication. And I highlighted news media because that's the largest group of them, but it also applies to educational and scientific institutions who are doing requesting. And news media requests only being charged duplication is the lowest tier of fees. And then the third group is everybody else, right, who gets put in the middle, and they get search and duplication, but not review. So that's the basic structure of the 3 categories. But the reasons that people end up, so it sounds sort of like people would be getting charged fees. I see a question maybe from Mark.
Thank you. And Margaret, I apologize for interrupting you. But this is one of the big differences, I think, between FOIA, perhaps, not terribly familiar with FOIA, versus Oregon's public records statute. In that in Oregon, there's a public interest review and balance to determine, whether or not, for Oregon anyway, fee reductions are permitted when there's a public interest involved in the request. Whereas it appears here as though there's no weighting of public interest. Rather, it's pretty much what type of requester you are will determine sort of the outcome of fees. Is that a fair, real quick, I guess, summary? Or am I premature knowing that this is only slide 2 of 13?
It's both accurate and premature all at the same time. But it's a great question because it's interesting because most states actually don't have a public interest fee waiver or fee reduction the way that you're discussing Oregon's statute to have. The federal government does have one, but it starts with these as the baselines and then reduces from there. So in fact, although these are the baseline fees that are using this categorical approach, as you rightly identify, to sort of proxy, right, for what we imagine to be sort of more public and more private interest requests. Any category of requester can request a reduction if they're a reduction or waiver of fees if their request is in the public interest. So that's actually one of the reasons why, even though it looks like, for example, there would be some fees recouped under the structure, right? At least for the every other requester category, they would recoup search and duplication costs. Shouldn't some amount of fees be charged? And there's a variety of statutory reasons why that doesn't end up being the case, and the public interest fee waiver is one of them. So if you'd flip ahead one slide, I'll give you a few of the others, and then I do have the fee waiver provision on my next slide so you can see that. But one of the reasons is that that the federal government charges very little is that the definition of news media is quite expansive. This was revised. And so that category of duplication only costs is an incredibly broad category. And I think appropriately so, right? Because the nature of news media has changed, as of course you all, as some of you are journalists, right? As you know, so much more of our news content is being produced either freelance or through sort of less traditional media outlets. And so that definition being so expansive itself has the effect of sort of reducing fees to some significant extent. And if you slip one slide ahead, the next reason is that there's several circumstances under which the federal government is disallowed from charging fees entirely. So even the otherwise applicable fee categories can't be charged. So there's a few reasons. So under subsection 4, these first two bullets, if the cost of collecting and processing the fee are likely to equal or exceed the amount of the fee, the federal government just can't charge it. So this has a certain logic to it, but it also means that most agencies have picked a blanket number. They'll say, if the fee is less than $25, or if the fee is less than sometimes $50, we just don't charge it. And so lots of requests just fall under that category because, it's just, they aren't hugely burdensome. And so they fall below whatever the agency's cutoff is. The second bullet point is for any non-commercial requesters, that's news media and the other category, the agency can't charge for the first 2 hours of search or the first 100 pages of duplication. And of course, now records are almost always produced on CD. And so there isn't really a duplication charge to be had anyway, or emailed sometimes, right? There's no cost to that. And so, if it's only 2 hours, if it's a pretty limited request, that can't be charged. So if you combine those two things, if the first 2 hours can't be charged, and then whatever, tiny fee would be after that is less than the, say, $50 threshold, that just covers a huge majority of requests that don't meet the threshold for being charged at all. And then this third exception is when the agency misses a deadline. And this was sort of Congress trying to make more carrots and sticks for agencies to make the deadlines. One of the sticks was if you miss the deadline, you're not going to be able to charge search fees, or if it's a news media requester, duplication fees, since those are the only ones that apply. And so, the federal government has a huge backlog. It doesn't meet its deadlines a lot. And so there's a lot of requesters who can't be charged search fees for that reason as well. And when you stack all of these sort of exemptions to fee charges, the expansive news media request, and then if you flip one more slide, you'll see the public interest waiver that we were just discussing. If you stack those all together, you're talking about, really a small fraction of requests that are even eligible. Did I see your hand again, Mark?
You're muted, Mark.
Sorry, Professor. I apologize. I do have another question.
Of course.
Because Oregon's law, again, permits for the charging in Oregon, and I'm sure with the federal government, there are a lot of exempt there's a lot of exempt information from public disclosure. And one of the things that in Oregon that is permitted is charging to determine whether or not information that is being requested is exempt or disclosable. And I've noted here that under FOIA, there doesn't seem to be any recognition of the need for the feds to look at whether or not information that is being requested is disclosable or not. Can you address that for us? Because I would be interested and curious as to how FOIA addresses this particular issue as well. And I apologize in advance. I'm trying to compare apples and pineapples, and I realize that. but I'm just trying to get a balance here. And so thank you for addressing that. And sorry for the interruption.
Oh, no, please don't apologize. I certainly want to answer you all's questions. That's the most important part. So I'm sorry about the slides again, would you mind going back 2 slides? So the only way, so just like with I think every state, sorry, one forward from there. I apologize. This one. As with every state's open records laws, federal FOIA also has a set of enumerated exemptions that allow withholding or redactions where material is covered by those exemptions. The only so that's what we call review time. So search is looking for the records. Review is when you have personnel going through those records to assess whether there's any exempt material. And then duplication used to be literally a photocopying charge by page, but of course, like we're not doing that anymore. So one interesting thing is that the only kinds of requesters that can ever be charged for review time are commercial requesters. Right. So if you look at, I'm at the wrong, sorry, slides have got me. There was maybe two back from here is the original 3 categories. Yes, there it is. Okay, so that first category has search, duplication, and review for commercial requesters, but review time is not charged for any other kind of requester under the federal statute. Does that answer the question? Okay, great. All right. So I will say, like I said, when you stack all of the kind of exemptions to being able to charge fees, along with a pretty expansive news media definition, along with a public interest waiver provision, there aren't a lot of requests percentage-wise that end up eligible to be charging fees. And the other thing is you can submit as many requests as you want. You don't have to put everything in one request. So for example, commercial requesters, I think not nefariously, but just tend to request a particular record they need, and then another particular record, a particular inspection report or a particular, regulatory document. And so they may submit lots of requests, an individual commercial requester, but each one is pretty discrete, and not any given request meets a threshold for being charged necessarily. So even commercial requesters don't often pay a lot. I will say, the fee categories, these basic 3 categories up on this slide, are, Congress's legislative history is pretty clear that they're linked directly to Congress's vision for FOIA as a democracy-enhancing tool of oversight and accountability, right? So the House of Representatives, official analysis of the law that created these fee categories, which came into existence in 1986. A quote from that report says, "The effect of the changes in fee and fee waiver policies will be to increase use of FOIA by the press and by public interest and other nonprofit organizations as well. An increase in government oversight by these groups is fully intended," right? So the idea was to facilitate that, right? To facilitate that use and to lower, and in many cases, eliminate entirely the financial barriers to effective oversight. All of that adds up to very little fees collected. So across the federal government, about 1% of the cost of FOIA is recouped in fees, which is, I think we can all agree, a very low number. Even commercial requesters are very low. My best estimate suggests that, I have it sort of agency by agency, not government wide, but for example, at the SEC, the year I have data that I studied suggests that the SEC recoups about 1% of the costs associated with commercial requesters in fees charged. FDA similarly was just below 2% for commercial requesters only, right? So that's like the highest fee category. And in fact, at FDA, the year I studied, nearly half of the commercial requesters were charged no fees at all, right? Much less the non-commercial requesters. So there are agencies, by the way, that basically don't charge fees. So for example, U.S. Citizenship and Immigration Services, which now receives about 200,000 requests a year, are almost all people seeking their official immigration record called an A file. And USCIS, because it's people trying to do that, even though mostly actually it's lawyers requesting them on behalf of their clients. So you could imagine a theory under which the lawyer is a commercial requester that has a business or something. But USCIS has decided as a blanket matter, they don't charge for A files, right? It's mostly because it's the people's interest that's being served, the individual who needs their file. And I think that makes perfectly good sense, but it does mean that out of their 200,000 requests, 96 or 97% of them are for A files. They don't even bother to count time, right? So this is sort of a long way of saying fees are just not a barrier to entry at the federal level for the vast majority of requesters. So I see a question in the chat about how much money we're talking. And I was about to say something about that, so I'm super glad you asked. So the government definitely has to invest in FOIA, right? The costs of FOIA are undoubtedly high. They're clearly much higher than Congress ever anticipated. When Congress initially passed the law in, well, actually, it was in the 1974 amendments to FOIA that sort of changed it into its present form. And there was a cost estimate that was done with it, where Congress estimated that government compliance would cost $100,000 a year, $100,000 a year, which today would be roughly like $500,000 a year. In contrast, you know, in fiscal year 2019, the last number I pulled recently, agencies spent about $500 million a year, which is, you know, $500 million, processing FOIA requests and appeals and litigating FOIA denials. So, you know, that's more than like 1,000 times what Congress imagined, which, like, I think we should be honest about what that cost is. It's obviously a substantial amount of money. It's hard, though, to conceptualize what that means in terms of the federal government's budget, which is, of course, vast. You know, you could compare that number to some things that makes it seem like a pretty big number, right? That's a bigger number than the whole budget for the FTC or the NLRB, for example. It's also about the amount that we spend on military bans. So, you know, I'm not sure, like, we spend a lot of money on military bans. So, you know, it's hard to say how to compare that vis-a-vis the other things we spend money on in the federal government. And that number is, of course, across about 120 separately reporting federal agencies that administer FOIA. So when you aggregate, it looks like a very large number, but for each individual agency as part of their budget, you know, it may not be significant. That said, it's a big number. And I think it reasonably raises the question of who is actually using FOIA and are these costs worth it? And that's a question I've spent a lot of time studying. And, you know, sometimes my own research, though I regret it, has sometimes been used by others to argue that FOIA is in fact not worth it, right? Like it's citing mostly my empirical findings that the vast majority of requesters are not journalists or watchdog groups. And if you might forward to the slide that has like a round graph on it. I don't know how many ahead that is. That one. So this is a snapshot of the data that I report in my recently published book. The 60 agencies I included in the study account for 3/4 of the federal government's total volume of FOIA requests. And what's immediately clear from looking at the data is that FOIA is largely used for purposes other than sort of democratic oversight by public-minded requesters, right? Two groups of requesters dominate the landscape for the federal government. One is people seeking their own records, whether they're their own immigration files, medical records, their own complaint investigations, genealogy-related research, things along those lines. The second group is commercial requesters, so businesses who use FOIA as part of their profit-making enterprise. But I will say, I've dug into these numbers and I've studied these requesters. I've stared at these businesses. I've interviewed people on all sides of this. And mostly what I find is that these requesters are not engaged in what we might think of as harassment or abuse of the process. They appear to have legitimate and sometimes vitally important interests in these records, just not the ones like the press do, right? They're just different interests. They also don't, as far as I can tell, appear to be anyway motivated by or submitting higher volumes of requests because the fees are low. It just doesn't appear to be connected to fees in any real regard, because the interests that they serve, you know, they're there on an either individual basis, or the businesses sort of want and need these records for legitimate business purposes, and either, you know, they either pay the fees that they're charged or they don't pay the fees they're not charged, but it's not really affecting their requesting. So if you flip a slide ahead, I'll just describe briefly who these people are so you can see what I mean when I say I think these are not abusive requests. The biggest group of requesters, first-person requesters, is dominated by immigration-related records. So I mentioned U.S. Citizenship and Immigration Services before, but immigration-related requests are driving FOIA numbers government-wide. This is some back-of-the-envelope math, I recognize, but it pegs more than half of all federal FOIA requests as first-person requests made by non-citizens or their representatives, like their lawyers, seeking their own immigration records. These are typically individuals who are either in removal proceedings, deportation proceedings, but there's no discovery in immigration court, which is an administrative court. And as a result, the only way they can get access to their own file, the file the government is using to try to deport them, is through FOIA. The other situation that non-citizens use FOIA for is when they want to apply for a new visa or to adjust their status from a non-immigrant to an immigrant visa, a green card holder, or for citizenship. And they need their own immigration records to do it. So they have an individual, personal, totally like understandable, legitimate interest in these records, sometimes vitally important interest in these records, right? Defending in some cases against deportation. And so that's why they're there. But first person requesting is not confined to immigration agencies. If you'd flip a slide ahead, I have just sort of, these are not all of them, but these are some notable examples of areas where I found substantial volumes of first person requesting, and I've grouped them loosely by the agency function that prompts the request. So the first category, like with immigration, instances where agencies act in an enforcement capacity, we see pockets of first person requesting in lieu of the availability of administrative discovery. So for example, at the IRS, there are some administrative processes at the IRS involving penalties and findings where there is no discovery availability. People use FOIA. Agencies that administer benefits also see these requests filed by people who are trying to best position themselves, either with respect to their application for or an appeal of denial of benefits. Like FEMA for a while was directing people who had been denied FEMA benefits to file a FOIA request before they filed their appeal, right? That was the way you got your records. Another category arises at healthcare providers. So this is when agencies that do direct healthcare services. So Veterans Health Administration, Bureau of Prisons, people are trying to get their own medical records, oftentimes for continuity of care. They're now trying to get a private provider. And finally, people who are using FOIA to do genealogy research, curiosity, right? And we have a vast trove of information in the federal government of which there's a lot of interest, right? So it sort of makes sense. If you'd flip a slide ahead, this is my like 30,000 foot view, but to talk a little bit about who our commercial requesters are. While they only make up 8% of requests government-wide, this slide shows how at some agencies, they really are the vast majority of requesters. So these are agencies up here where I was able to verify that more than 50% of their requests are from commercial requesters. Businesses have a large range of reasons for turning to FOIA. My co-panelist, Tom Sussman, has lots of wonderful thoughts about all of the legitimate things that businesses are doing with FOIA, and I completely agree with him. And I've been persuaded over the years that there may be some ancillary public benefits as well to commercial requesting. We want businesses to understand the regulatory landscape so that they comply. We want them to be able to, best advocate for themselves before an agency. Some businesses are, in fact, trying to get a sense of what their competitors are doing. That may well improve the marketplace for consumers, right? Robust competition for that information, which is, in fact, public. A lot of it is due diligence. Businesses who are trying to either do financial due diligence, so they want to acquire a company or do business with a company, and they're looking to make sure there's no, say, SEC investigation or something like that. Or environmental due diligence. If you want to acquire a commercial property, if you have to go through certain due diligence steps to make sure there's no environmental contamination so that you're not liable under CERCLA for a cleanup if a problem is later discovered. So these are, business interests we probably should mostly support, right? That, records that businesses need. Now, at the federal government level, there are some businesses also who engage in what I call information reselling. They request pretty large volumes sometimes of federal records and resell them at a profit. usually by adding some value. They're indexing them or categorizing them, database warehousing them. People can get quick access to them, or they're doing the requests on behalf of businesses that don't want to do the work of FOIA requesting themselves. I would say that's a small minority of commercial requesters, but it's certainly present at many agencies, which is sort of an interesting thing as well. Mark.
Thank you. You finally opened up a can that I was hoping you would. So one of the challenges, and we've had a number of groups join us and share some thoughts about public records and charging and so forth. And one of the repeated sort of cautionary tales I've had, at least up to this point, has been that the use of fees is a really powerful tool in being able to get people to narrow their requests. One of the big challenges, as you can imagine, Professor, is that some people may not necessarily be familiar with the systems by which they're entering when they're asking for public information, and will make these rather broad requests. Can I have all the emails from XYZ between dates Q, R, and S? And you're suddenly faced with a monumental task in front of you. And these agencies will have the ability to say, look, you know, that type of request is going to cost you untold hundreds, if not thousands of dollars. Let us work with you to try to narrow this request so that we can avoid creating a financial barrier, if you will. Can you address whether or not that is something available in FOIA, and how can you control the amount of information people are requesting? I mean, I think it's a waste of people's time to produce information that people are not seeking, while also creating a financial sort of brick wall, if you will. Can you address that for us in this conversation as well? Thank you again.
Yeah, of course. And please call me Margaret. I completely agree. I think there is, you know, some of that happens at the state level. It does happen at the federal level. But I will say, with news media requests, it's harder because the fee estimates can only be about duplication. So you're talking about smaller amounts of money. However, members of the news media tend to be pretty goal oriented in terms of getting things on time. And if they know that production, you know, of a huge volume of records is going to take, you know, months, and they want something quicker, they usually, I will say, most agencies find that journalists are willing to work with them to narrow requests to get records quicker because they actually want things for the stories that they're doing. So that sort of takes care of one chunk, I think, to some degree. Certainly, maybe not perfectly, right? I think I'm not going to try to pretend that that's a perfect solution. For the non news media requesters, for our sort of other category, I think the federal government does the same thing. I think they do, because I think even though they don't end up charging very many fees, I think that they, and I will say sometimes I believe inappropriately, because I think sometimes they make up these numbers as a way of trying to you know, negotiate, and they don't really have necessarily a great basis for it. And sometimes I'm sure they do have a great basis for it. Some of them are expensive, right? And so they do say, look, this is, you know, what this might cost in fees. Can we find a way to narrow this? And so for that sort of other group, I think it's used a little bit more often. So I think timing is another big piece of it. I think for the federal FOIA officers that I talk to, you know, they're really like, we can get this to you quickly if you just want X, or if you just want Y, or let me explain to you what the options are for search and we'll come to an agreement on it, you know, and that way we can get it to you much faster. And FOIA officers I talk to seem to think that it's very productive talking to requesters. And so I think fees is not the only lever to push. I think timing is one as well. And then the last thing I'll say is that commercial requesters just don't tend to submit requests like that. Theirs are very discreet, and so they just don't end up in those situations. Tom, please weigh in.
Two comments. One is, while media requesters are often on deadline, they also frequently don't want the agency or certainly competitors who may be looking at the FOIA logs to know what they're after. So we often find that journalists will make broader requests and perhaps narrow them over the telephone even, so that the public won't find out what they're digging into. And that's not an issue of fees, but it's a strategy that's used. I also want to sort of jump in early on the commercial requesters issue, because as Margaret indicated, she and I have been had this dialogue going in a number of different forums, because I spent almost 30 years in private practice of law, doing a lot of FOIA litigation on behalf of nonprofit organizations in the public interest pro bono, but also representing commercial interests. And I'll just use, the one example I keep coming back to is we represented a chemical industry that had word from EPA back channels that it was about to ban a chemical that would cost the industry, they'd have to close down plants. And so we made a request for everything the agency had, field offices, general counsel's offices, scientists, et cetera, on this particular chemical. Now you can imagine how it drove the agency crazy. And they said, look, this is ridiculous. This is going to cost you over $120,000 and take us a year. Our response, when can you start? It was a bet the business request. So, I mean, I put that in perspective because you say, ordinarily you think, well, anything that big, that's ridiculous. That's going to be a burden on the agency, and that also goes to the public purpose of the Freedom of Information Act, is that without having that information, the likely higher cost to both government and the private sector, because it would have all had to be litigated after the fact, since, as you might guess, we uncovered no evidence that the chemical was in fact toxic. So, I mean, there are lots of examples. Competition-wise, I represented a number of businesses that routinely ask for competitors' contracts and information relating to contracting at the federal level and state level. And this was always used to improve our ability to get contracts the next time around, usually by offering more and bidding less, or, for less. So I'm a big fan. Margaret's absolutely correct. Commercial issues didn't raise their head, in the early days of FOIA. But now I think, and let me just say before turning it back, I'm a big fan of full freight charges to commercial requesters. So when you're crafting a set of FOIA guidelines for fees, there's no reason why you can't and shouldn't recover the full costs of, as the federal law would allow, full costs of search, duplication, and review. That the federal government doesn't do it only tells you that, they don't, it's such a small percentage for most agencies that they just don't bother. And I do think it would be a mistake to suggest to the agencies that their budget has anything to do with the fees they charge, because that's a perverse incentive. But on the commercial side, Food and Drug Administration, EPA agencies that do a lot of business of interest to corporations, Defense Department, full freight should be charged every time.
I couldn't agree more on all those points. Absolutely. And I mean, I would say the only thing I worry about with commercial requesters fee charges is not to make them so onerous that it becomes worth it to game the system in some way, because the last thing I want is for agency officials to try to sort out whether this person who submitted a request in their own name as an individual is actually, an administrative assistant at some company and whose interest is really on the line. That doesn't seem like a good use of agency's time either. And I think if it were too onerous, some companies might be incentivized to try to find workarounds. But I don't think we're anywhere near that level, honestly. Most companies that I talk to that are doing FOIA requesting, they're like, send me the bill, I'll pay the bill. This is pocket change, right? To get the records that we want. So I completely agree with Tom's assessment. I will say, and I think Tom's points really bolster this. None of these things that dominate FOIA at the federal landscape, despite the low fees, I think are really abuse or harassment, right? These are not abusive process. These are legitimate interests that we're seeing being represented. And I will say, though, that, I actually tried to look into this question because I know there's a lot of interest in it. And so in the book, I take on the question of harassment and abuse. I dug through federal records trying to find instances where even like a particular individual with a particular agenda might have, just, gone at it with FOIA just to try to make a problem. It's hard to find those instances at the federal level. That said, public reporting clearly shows that there have been instances where I think people have sort of reported as harassment and abuse certain types of FOIA requests. Interesting, mostly at the state level. And the reason is most of those that have been reported on have centered on academic institutions. So we're talking about, for example, climate change researchers, tax policy reform academics, researchers who have taken advocacy positions as public intellectuals and have been sort of targets under state laws. And it's not just coming from one side of the political aisle. The left did this. If climate change, I think, was one that made the media a lot. That sort of kind of conservative activists were trying to go after climate change researchers. People on the left targeted travel expenses and cell phone records of a UVA law professor whose research on religious liberties was used to support certain state legislative efforts allowing discrimination against the LGBTQ community and curtailing access to contraception. And I think it was reported on. I think, I agree. I think that's sort of like a use of FOIA as a form of harassment, right? Requests for personal information of researchers that use animals for scientific purposes. That was deemed so harassing that some states have amended public records laws to specifically protect them. I will say the range of academic research targeted in this manner appears to be growing over time, unfortunately. And as a result of some of these more notable instances, there's some calls out there for sort of state laws to protect academic freedom with some sort of researcher carve out or to state open records laws to protect individuals in academia. Recently, I talked to a journalist who was working on a story about state records, open records laws that were being used with K-12 educators concerning the sort of alleged teaching of critical race studies materials in K-12 education. And so, I'm not sure what the right answer to those questions is, but I'm not sure that's really a question of there may be instances where we could agree there was some sort of harassment or abuse under the state process, but the basic question there is one of academic freedom, I think, more than it is about restructuring all of open records laws to accommodate one area where we're seeing a tension between our desire for transparency and our desire for academic freedom. And so that's something that I think might be worth just considering on its own terms, and for state legislatures to think about, how and if they want to protect academic freedom at various levels of education that's offered in the state. And that is a question that I think maybe is distinct from the questions that we're sort of dealing with about fees, because I don't think fees are driving away any of those individuals, right? I just don't see that as being one of the key dynamics going on in those instances. Yeah, Steve.
I'm sorry to interrupt. This is a really great discussion, Margaret, and all of your answers are really enlightening. I want to make sure that we have time to get to Tom as well. So maybe if we spend another maybe 5 minutes or so going through the rest of the slides, and we can circle back with questions for both of you at the end.
Yeah. Absolutely. Yeah. Let me just sort of quickly fast forward. I think we got through most of what I was, and this has been a great discussion. You can flip forward a slide. I was just going to briefly mention that I did actually a deep dive on how news media actually use FOIA at the federal level. And I think it should be reassuring, because my data sometimes feels unsettling, like, oh my gosh, it's not really doing the work we wanted to do. But when you look at what news media are actually able to accomplish with FOIA, even with all of its flaws, even with all of its delay, it's incredibly impressive. And so, you know, I looked at examples, and interestingly, there were sort of three big categories that members of the news media who use FOIA a lot were using it for. One was exactly what we imagine, uncovering government waste or abuse or corruption. So here's an example of a story about Scott Pruitt's extra security detail and how much it was costing the taxpayer. Obviously not Scott Pruitt's only problem that he ended up having in office, but one that came early. If you could flip forward a slide. The second big category is influence over government decision-making. I think there might be a couple of clicks on this one with some example articles, but lobbying, patronage, agency capture, topics that go to the heart of the purpose of the law, right? So here's like a couple of instances where stories were broken using FOIA that go to those questions. And then the third area on the next slide is that actually maybe surprised me the most was national security. This is sort of counterintuitive because there's a narrative that the national security exemptions are so broad that it's not really that useful in reporting on national security. But actually, an empirical account suggests that news media requesters are actually more prevalent at many agencies that are security adjacent, such as the ones I listed here. And also my interviews with journalists sort of showed some examples, and maybe there's a couple clicks here too for some stories about where journalists have used FOIA very successfully here in national security related areas. One of these is about conditions in privately run immigrant-only prisons. Another one about the security around the Dakota Access Pipeline at Standing Rock protests. And so I'll sort of, I will say, I took away from this piece of my research a real feeling like we have to do everything we can to make sure that the barriers are low for news media, especially because this is still such a valuable tool. Christina Conningizer, who's a law professor at the University of Utah, is doing some really interesting work at the state level about how FOIA or open records laws are being used to monitor law enforcement. And I think we're going to have more and more research coming out in these areas that will bolster the idea that these tools are still vital. So I really applaud your work in seeking to look at reforms. I think I have one last slide that was actually just funny, but and then I'll sort of stop there. And I'm really excited to be sharing this venue with Tom. We always like getting together on these things, so I'll pass it over to him.
Okay, great. Thank you so much, Margaret. That was fantastic. And if you have time to stick around for the second half, I hope. Okay. So hopefully, if there are additional questions that come up for people for Margaret, we can address those at the end of Tom's remarks, along with questions for him. Tom Sussman has been involved with the Federal Freedom of Information Act for over half a century as a lawyer with the U.S. Department of Justice, General Counsel on the Senate Judiciary Committee and the Subcommittee with jurisdiction over FOIA, a partner in a major law firm where, among other issues, he handled information and privacy law cases for clients, and most recently as Director of Governmental Affairs at the American Bar Association. Tom is now part-time strategic advisor at the ABA, which gives him time to participate as a member of the FOIA Federal Advisory Committee of the National Archives, chair of the Steering Committee for Open the Government, member of the Board of Directors of the National Freedom of Information Coalition, and president of the DC Open Government Coalition. I will add that I think many people don't realize that FOIA actually passed originally in Congress in 1966, but the version that we now know as federal FOIA really didn't come about until 1974 after Watergate. And in his role as chief counsel to the Senate Judiciary Subcommittee on Administrative Practices and Procedure, I think it's fair to say that Tom was the lead Senate staffer involved in the drafting of these pivotal changes in 1974. And I dare say at least some of the words, if not many of the words in the current FOIA law probably were penned by Tom himself. So without further ado, Tom, it's a pleasure to have you here. Take the floor.
It's great to be here, and a subject I love to talk about. So give me an audience and wind me up. And Margaret, as she said, she and I have We go back a long way. She was involved in DC open government work. I don't know. I won't say how long because she looks so young. But I, in fact, gave agencies advice when I was in the Justice Department, not that they could not charge for information requested by a veterans organization relating to the Veterans Administration testing of hearing aids. And ultimately, they refused to provide the information. They said there was, forget about the charges, it was exempt because it was commercial, trade secrets, and they lost that one. So I felt like, okay, vindicated. I'm going to run really quickly. I had an hour and a half's worth of things to talk about. No, just kidding. But I think the Q&A will be much more fun. And I'm going to riff back to one of the last things that Margaret said, and that is talking about police oversight. Next week, the DC Open Government Coalition is having a summit during Sunshine Week on police transparency. And I think just in the last 48 hours, the Post reported on data scraping that they did and FOIA information across the country to come up with this article that documents police misconduct and payments made by police departments to settle them. And they came up with a $1.5 billion figure, and some individual officers involved in dozens and more of incidents that resulted in payouts. So, I mean, FOIA does work. It's a remarkable oversight tool. On the subject of fees, interestingly, the initial Freedom of Information Act had 7 words that, governed, that allowed the agencies to charge for FOIA requests. And basically, it said that agencies should make records promptly available in accordance with published rules stating the time, place, fees to the extent authorized by statute and procedure. Okay, fees to the, that was it. 7 words. I counted yesterday. I went back to the current statute, 87 lines, like 3 pages. So, and part of that's because, and it's what you're going through now, okay? It's because the 7 words didn't work. From the start, from day one, researchers, requesters, courts have found 3 problems with the Freedom of Information Act administration. Delay, that's almost always the first. Excessive redaction and fees. At the state level, the federal level, in the 70s and in the 2020s. So it's been a long time. And so you can see the way the federal law, every time we've passed an amendment in Washington, we massage two aspects. One is the time limits, trying to deal with the issue of delay, hasn't worked. And the other is the fee provision, trying to deal with the issue of cost to the requester. That doesn't work either so far. Well, it's better. I want to get back to the, Margaret, I think, does a great job of talking about the democracy enhancing purposes of FOIA, accountability of government, et cetera. And so, and that number of, military bands that we used to use military golf courses. I think it used to be, I don't know what the number is now, but we used to talk about B-12 bombers. 1 airplane costing more than the entire Freedom of Information Administration in the federal government. And so when you begin to put, and also public relations activities by the government, which is perhaps a little more apples and, well, maybe oranges and tangerines, because public relations is what government wants you to know, and they spend a lot of money on that. FOIA is often what you want to know and they don't want you to know. And so I don't have any conscience about saying that the government ought to pick up those costs. Now, the controversy dates back. I mean, many of you who looked at the federal system, wonderful Nino Scalia, who was a good friend of mine in the 70s before he took the FOIA on and became a judge. But Justice Scalia wrote when he was a law professor that the Freedom of Information Act was a Sistine Chapel of cost-benefit analysis ignored. That the free lunch aspect of FOIA is significant, not only because it takes money away from the Treasury that could be better spent elsewhere, like on military bands and golf courses, but also brings into the system requests that are really not important enough to be there. I hope that doesn't include commercial requests or immigrants' requests or refugees' requests for their A1 files, or frankly, my grandson, who I taught how to use a FOIA in doing a high school research project. I think it's well worth it. The information belongs to the public. I don't have to tell you this. It informs voter participation, oversight, ultimately cost savings, and it's worth the cost. So I'm not gonna go through history, but history. 74 amendments. We tried to get things under control by saying that agencies could only charge the direct costs of search and duplication, and furnish without charge where the agency determines that the waiver or reduction is in the public interest. That's still in the law, and so let me just jump quickly to some current concerns, and then hopefully we can get into a dialogue, because much of what I would have said, Margaret, is preempted. The difference being is that hers is based on research and discipline, and mine is based on old age. Okay, concern number one, as Margaret said, research has shown a lot of FOIA requests are first-person requests, where, by the way, under our Privacy Act, if you're requesting your own record from a system of records, the agency cannot charge you. It's not permitted to charge you. And then a lot of them are commercial requests where full costs of search and copying and review can be charged. So we can set that, and we both agree on that. We should set both of those categories aside. First-person requests, if I needed to know how much I'm supposed to get from Social Security or a veteran's claim or an immigration appeal, that seems to me that the government has no business charging for that. Commercial requests recover everything. We put that aside. Secondly, the discussion which we had, and I think Mark raised, absolutely legitimate, the use of fees to force requesters to narrow their requests. And I work on this FOIA advisory committee for the archives. Half of us are in the private sector and half are government representatives from the various agencies. And they admit that when a request comes in, if they say, your request for any and all documents relating to X, Y, and Z, including emails and metadata, well, we can do this. I can't think of any exemptions right now, but it's going to cost you a boatload of money and take a really long time. And that is almost always, according to my government colleagues, enough to bring both parties to the table to discuss, all right, what do you really want? What do you want first? And as Margaret said, a lot of them, they wind up not charging in the end because they really did agree to narrow. It's sort of, a joint agreement to narrow the request to be more reasonable in scope. The third point is that Congress has always tended to favor media requesters, and this is historic too. The original Freedom of Information Act was born from a book written by, I guess, a Publishers Association underwrote, Cross, The Public's Right to Know, The People's Right to Know, I think is the title of the book. And then both in 65, 66, and again in 73, 74, the law wouldn't have passed and the amendments strengthening it would not have passed without the media, period. Okay? I mean, in the 60s, the American Bar Association, thank you very much, was a strong supporter of FOIA. but there weren't, there weren't other nonprofit organizations, advocacy groups, et cetera. So the media really pushed it over the goal line. And as you probably all know the story, Lyndon Johnson had a veto statement out at the ranch on the 4th of July when, his, I guess Ted Sorensen, his communications advisor, said, you can't do that. You're already in deep doo-doo with the press because of, a lot of other things going on, Vietnam and the like, and you need to do something to ingratiate yourself. So he signed it. Okay. The media did that. 74, the same thing. Gerald Ford vetoed the amendments, and it was press organizations, publishers, editors, all the groups, radio, TV, that pushed it over the finish line. So Congress has always had a soft spot in its heart for waiver or reduced fees. And, I think that is entirely appropriate. The one problem we do have, and you have to, when you're talking about media representatives, and I guess Margaret you didn't address that issue, but you probably have run across it, and that is, what is the media? There's litigation on that subject. Does that include bloggers, influencers, neighborhood newsletters, Instagrammers? I don't know what, TikTokers, I don't know if what, but I mean, there are a lot of people who do that regularly and have a very large, there are Instagram, I guess, Instagram participants whose followers are much more than many, many newspapers.
Michael Crone is an example.
So, right. So, I mean, what do they get? Congratulations, Michael.
No, I'm a social media Luddite. Mark is
okay.
misleading you.
But I mean, so, and so, the agency would like to be able to have you make fewer requests or get some money out of you. But when you show them what your following is, then it's hard not to win that case that you are a, representative of the media. I think ultimately the issue is, a tension between, I guess, journalists and scholars and requesters who see fees as a barrier to access, and legislators sometimes, government officials most of the time, and judges often, who see fees as helping to ensure that the government can recoup costs and control these, vexatious or burdensome or harassing requesters. And I don't have an answer for that either. It does happen. The chair of the DC Council, when I was testifying, used an example of a request for his emails, and there were lots of them that were requested, and he basically said it was a weaponized request. Okay, I mean, we're trying to figure out how to deal with those vexatious, weaponized, et cetera. That's a whole other issue. Emily Harris, I'm sorry, you have your hand up. I have trouble multitasking here.
Oh, no, geez. And thank you so much for coming. It's really an honor to hear both of you, and it's been very informative and interesting.
Wait. I'm not finished. I want to finish I want to make 3 more points.
No, I did just want to ask one question about this definition of the media, which I'm happy to save if you want.
No, that's okay.
Margaret went through the expansive federal definition, and I was just wondering if in your experience that is flexible enough to actually, lay to rest this question of, well, we can't define the media, so we can't, use the media, give the media a special channel. Obviously, the media has a particular channel at the federal level, but is that expansive definition, is that good enough?
Well, Margaret probably has research on the subject, but I want to also make clear that it's not just the fees issue that's tied to representative of the media, because there's also the delay. Congress tried to address the problem of delay by giving the media expedition in their requests, but not quite the same standard for both fees and expedition, and so that's kind of gotten mixed up, and I fortunately haven't had to unmix it. Margaret, have you fathomed that particular labyrinth?
Sorry, I'm trying to Teams with the buttons. So I don't actually, so Tom's giving me too much credit, as usual. I don't have research on this question, but I will say in my experience and in terms of what gets litigated, which I know a bit about, expedited requests don't tend to get litigated hardly at all because litigation isn't fast. So by the time the expedite, it's just like moot, like it just doesn't make it to court. So there's very few cases on expedited review. I mean, there are some because people stick with it and all that. But so putting that aside, the news media definition is, that definition I put up is used for the fee category. That's the same standard. So there is, Tom's right, there's a slightly different one, right, for expedition, but that one is used for the fee category. And I will say its expansiveness is mostly held. It is including bloggers. It is including, all sorts of non-traditional media. I haven't seen courts starting to try to winnow it down. I mean, it's really quite broad, and I think agencies are treating it at face value. Now, what do people usually need to show? They need to show some history of past publication. They have to show an audience. They have to show a distribution method. Like, obviously, that's easier with social media, but I guess I'm of the view that that's not inappropriate. I mean, I think I'm old enough that I still get a newspaper that's delivered on my front stoop, which I recognize is no longer how people get their news. And I want people to get accurate news. So I think that all of these types of media should be in that definition. And as far as I can tell, but I don't have like great data to share with you on this, it's encompassing them effectively.
So let me just make 3 sort of recommendations and conclusions, and then we can go on to further discussion. The first, and I've been on different advisory committees, commissions, task forces, et cetera, and there's no question, at least at the federal level and probably most states, that agencies need more resources to do their job efficiently and effectively under the Freedom of Information and open government laws. And that just includes not just responding to individual requests, but I mean, a lot of attention is being paid now to proactive disclosure, to try to find areas where there are lots of requests and you want to be able to give people the opportunity. I mean, I just signed up for the IRS system. Boy, you take a picture of yourself on your camera in order to be identified to sign in. But once you sign in, I mean, you have access basically to your history, to your payment history and IRS, that information. That I'm sure costs a lot of money. But there are a lot of areas we talked. Margaret talked about the immigration issues. We tried very hard to see if we can't push towards some routinization of access so that you don't have to every one does not involve retrieving, reviewing, researching, and delivering a file. So that's one. Resources are important for both the proactive disclosure and keeping the train running on time with requesters. The second is, I think reporting requirements can be helpful to know more. I mean, that's another area that we put in for the first time annual reports in the 74 amendments, and it's now grown into great lengthy requirements for reporting and FOIA officials, et cetera. But it does, and Margaret and I've had this discussion before, we actually could use more reporting at the federal level. As much as we have, to be able to assess without an academic having to spend half of her, sabbatical and 2 other academic years, going through FOIA logs, and then not having a necessarily accurate view in some areas. So reporting, and finally standards. I mean, the clearer the standards, the less problems, the more predictable, the less litigation, and whatever you decide you want to do, whether it's charge the hell out of commercial requesters, give it free to individuals, give it waivers to media, public interest determined. Public interest is nice, but it puts some meat on the bones of what's public interest. Otherwise, you're going to find it's going to take 5 years before you're going to know. 2 courts will have different rulings, and so make it clear. And if you're worried about that vexatious requester, there may be other ways of dealing with that than a general, I think Margaret made this point, than sort of skewing a fee system for the infrequent vexatious requester. Connecticut has a system where you can go to the Connecticut Freedom of Information Commission and ask them, please, to relieve me of having to respond to this requester because the guy's driving is crazy. That may not be the only answer, but at least there are some answers to that. And maybe if the agency says, if you have some standards for, truly unreasonable requests, and that's not a journalist going back 3 times to try to complete the story. And it may not even be a business asking for information that would take, a year and $120,000 worth of time to answer. But there may be a way of, providing a definition in the statute that will relieve a lot of pain later in the game. So I look forward to any questions and discussions. This is an interesting subject, actually.
I think we're all very interested in it. Thank you very, very much. Let's see. I think Steve had your hand up. Did you want to go ahead?
Yeah, thanks, Emily. So I'm curious, what the lack of fees, the fact that there's just sort of, it seems like it's so rare that federal agencies collect fees. In both of your experiences, I'll start with you, Margaret, like you've interviewed a lot of these people. What do you think that's done to the culture of federal agencies and their FOIA officers? And can you compare that to what you've witnessed at the state level in your experience? The culture vis-a-vis the FOIA process?
Yeah, I mean, I think, well, I'm not sure if I have exactly a direct answer to your question, only because fees just don't tend to come up in these conversations because they play so little role in what the federal FOIA offices do. But there's been, but on the culture question, I actually do find it really interesting. I think, I think probably Tom knows more about this than me, but over time, there's just been an incredible professionalization of FOIA officers, including professional associations, enhanced training, enhanced stature within the agency, grade level pay, and everything, right? Where they have to fall in the org chart of the agency, that the chief FOIA officer has to have a certain level in the agency, right? That was statutorily designated at one point. So I think there's been a huge push toward professionalization. And of course, there's something about volume that allows them to do that because you can have dedicated FOIA staff. One of the things that I see at the state level is that these responsibilities are being administered by sometimes an untold and uncountable and unknowable number of entities within the state. Like nobody has a list of everyone that has FOIA obligations in the state. And most of the people answering requests have another job, right? Like they just also happen to be answering requests. That's not true at the federal level. Like you have in almost every agency, all but the tiniest agencies, right? But on almost every agency, there's dedicated FOIA office. So, I mean, I will say I don't know a huge amount about state budgeting procedures, but I have always thought there's more room for states to maybe push funding out specifically for FOIA administration, and or maybe to have pooled FOIA professionals who work for a group of, like a person who's designated to do that work for several smaller agencies. If a full-time person isn't supported by the volume of requests gotten in a certain place. I don't know how to structure that best, and certainly not, in any given state, but it is that distinction becomes very real because I think at the state level, like FOIA professionals, by and large, are really committed to FOIA and transparency. They believe in the mission. They believe in what they're doing and in the importance. They want to work with requesters. They may be overwhelmed. It still may not be nearly enough. I'm not saying that the situation is great, but the people that I meet feel a purpose to their job. And I think at the state level, a lot of times people do feel a purpose to their job. Their job just isn't FOIA. FOIA is like an annoying thing that happens on the side.
Yeah, Tom, do you want to weigh in on that? Yeah. I just see Tyler has his hand up after that.
First, the short answer to that question is from as Margaret says, they're professional employees at the federal level who are committed to administering the law, but it's not their money. They'll get paid whether they collect fees or not. But we thought when we put, again, another one of my drafting, and by the way, the $100,000 cost for FOIA is not a myth, because I came up with that number in 1974, because you had to put some number down, and we had no idea what the costs were. No one was keeping track of it. There were no reporting of how many requests there were or anything. So it just was one of these things where I threw a dart at the dartboard and it hit the floor. So, okay, that's the way that number was arrived at. But we did have attorney's fees for successful requesters in court that we thought would have an impact on agency decision making, because the agencies, I mean, who wants to be on the losing side and have to fork up a big amount of money? Well, two things. One is, it turns out there's a federal, I can't remember what it's called now, a central treasury account that pays attorney's fees across the government for all cases, with civil rights or tort or whatever. So it didn't come out of the agency budget anyway. But even if it had, it wouldn't have come out of the FOIA office budget. Okay, so that's finally, I think that this idea of needing resources is just it's one of these things that we have to be careful. The resources should come from the same place that resources come for your courts or for your it's due process. It's democracy for elections. I mean, where do we get that money from? We don't charge people. We used to charge poll taxes, right? You can't do that anymore. You shouldn't do that anymore. It's inconsistent with our democratic principles. And I guess I feel the same way about charging, for most freedom of information requests. I'll take my hand down now.
Sorry, my clicker. I think Tyler, you had a question, and then Michael, I see your hand as well.
Yeah, thanks so much, Emily. And thank you, Margaret and Tom. This is a fascinating discussion. But I think both of your recent comments just really highlighted, of course, we were just talking about the staffing capacity at the federal level. And I want to bring down, we've mentioned the state, and I want to, being here from a county perspective, I want to drop it down to the local level as well, because I think it's really, really critical to consider part of the restrictions that local governments have. And I'll put on my other hat that I wear at AOC from time to time, which is a revenue hat. And I think it's worth bringing up all of the structural restrictions we have on our revenue system here in Oregon, because local governments find themselves continually with fewer resources to accomplish a myriad of priorities. So I want it to be really clear, I think public records and transparency by design is a great example. It's something everybody wants. The reality is there are thousands of competing priorities, and what's the best use of those funds? So I just wanted to make sure, everybody was aware. At the local government level in Oregon, for the most part, our largest source of revenue is property taxes. Those are, of course, capped here by Measure 5 and Measure 50. In most cases, you have your property tax base growing by about 5% a year. You have that 3% cap, and you have some new properties coming onto the roll. So I want you to consider for the fact that, over the past year, we're looking at, I think the Seattle CPI index, we're looking at about 8% inflation. Governments are paying for goods and services just like households in Oregon are as well. So we have this growing problem where the revenues that we can bring in are in no way commensurate with the rising costs that we face. We also are preempted in many cases from raising our own taxes. I'll highlight beyond property taxes, for example, marijuana revenue was a growing source of revenue for local governments in Oregon. We received 10% of those revenues under Measure 91. The voters have since passed Measure 110. It caps those revenues, and we are preempted by the state from having any of our own local option sales taxes on marijuana items above 3%. So there's another revenue shortfall. And then finally, the last one is, of course, from the federal level, we cannot deficit spend. We can't pay for positions and cash the checks later. So I just wanted to make sure that it was really clear. We just have these structural revenue problems, and it's not that we don't share these laudable goals. It's that, what do we cut to come up with these resources. I think it's been mentioned. I would love if the state legislature or this group saw fit, if there's associated funding. I find myself in this position all the time when the legislature wants to do something, and I say, that's great. How are we going to pay for it? Because the reality is we don't have the resources at the local level to do everything. So I just wanted to put that out there. Thank you.
Thank you, Tyler. Michael?
Hi, thank you. And thank you, Margaret and Tom, for being here with us today. I want to go back to something, Margaret, I think you just kind of mentioned in passing, where you were talking about the users of the FOIA system and how a lot of them are pursuing interests that aren't necessarily this sort of government oversight interest that is motivating Congress, but that they generally seem like legitimate and good interests to you. And one of the examples, in fact, the biggest example, it sounds like, is people getting their own immigration-related records, which they don't have another avenue to get. And when you said that, it reminded me of kind of a preposterous situation we used to have in Oregon, where one of our local governments was literally charging crime victims to get copies of the police reports for their crimes under the public records law. And kind of the question this raises for me is like, well, if there are all these uses at the federal level, and I can't say for sure how many there are that are sort of parallel at the state level, that really shouldn't be public records issues. Like if the public records law is expected to bear all the costs of, victims getting their own crime reports, for example, then of course it's going to cost a lot and local governments are going to not have the money for it. But is this a fee related issue, I guess? Is there a way to see sort of providing for reasonable access to victims, to the information they need, to businesses, to the information they need to respond to regulatory actions that are being taken against them, and just kind of moving some of that stuff out of the public records law so that it's really supporting the weight of the government oversight function that it's supposed to be performing?
Not only could I not agree with you more, that actually, and not fees, is the central premise of my book. So is that, that FOIA is in fact becoming sort of crushed under its own weight, that we are shoving every possible information need that the public has into FOIA because it's sort of a pressure release valve, right? Since there is an option, no one's forced to go to Congress and lobby for some special way, but actually, Tom, I think very much more eloquently than me, described sort of portal access, described, proactive disclosure measures, described other kinds of things that agencies can do to prevent the need for people to file FOIA requests or public records requests at the state level. And I think that is the central thing that we have to start taking on, because otherwise, I think we're just going to have every year over year, we will have more requests. It will cost more money. The agencies will be more backlogged. They will go, Congress will hold more hearings. They will wring their hands more. We will do this forever. And so I really do think one of the things, that Tom mentioned that I've been an advocate for is requiring more detailed reporting, including detailed publication of FOIA logs by agencies, so that we know what these groups of records are that people need so much, so that we can start to think about more sensible strategies for delivering them. These are legitimate. I call FOIA requesters at the federal level information constituents, because they are agency constituents. They are constituents being served who need agency information, and they should be served. That should be viewed as a central part of the mission. To Tyler's point, and I apologize if I sounded insensitive to budgetary concerns, or like I thought that local or state officials were not in good faith trying to administer the laws. I didn't mean that. I just meant there usually isn't the budget for a dedicated personnel who views this as their primary job responsibility. And it's not because I think that the officials who do this work are not doing it in good faith. I do believe that they are. Just that it necessarily takes seconds. It's necessarily sort of a secondary role, right? And so I don't think anyone is operating in bad faith. I just the structure is not set up to succeed. And I think the funding is exactly that reason. But at the federal level, my book, the whole last third, details all the strategies I think we could be using to alleviate the pressure on FOIA. I think some of them may translate to the state level. Others probably don't, but that's but states are really hard to get data on. I mean, really hard. Who's requesting at the state level? Can anyone figure that out? Because I can't. And I know a couple of studies out there where people are trying, but it's really hard. It's really hard. I don't think we even know how many request states in like under state law are made. Like, does anyone know that?
We did a bit of study on that, Todd. I don't know if you want to share that with Margaret at some time if it's at your fingertips. But I think Michael, did you have your hand up right now again, or did you lower it? Yeah, lowered it. Todd, do we have information on that from that report you and Ginger did a couple of years ago, trying to get some survey data? Is that something it's at your fingertips that you want to share with Margaret, or you can share?
It's up on the PRAC site. I'll take a look. We surveyed a select number of public bodies at the state and local level to try to understand in the previous calendar year what that looked like. And interestingly enough, one of the biggest things we learned was that a lot of public bodies obviously aren't tracking the number of requests. They themselves don't know what's coming in and what's coming out. And so there's no standardization across your own processes, which of course leads to inconclusive results or inconsistent results with the same types of requesters or records within their own public body. But I'll find it on our website, and I can provide a link in the chat.
Yeah, that's really nice. Thanks a lot. Steve, you have your hand up.
Sorry, I was just going to mention, I've spent some time with that report recently because it does have some interesting data in it. And I think it's the volume is about 22 or 24,000 record requests, at least for the responding state and local agencies, which is a partial bit of the picture. But a huge chunk of that was at the local level, police reports. And there are kind of like these whole big classes of, requests that I think, you could deal with in a one fell swoop. So I think that's a really compelling idea that we're talking about.
I had a question for Tom. If I can't see your picture, but I'm assuming you're still here. You had mentioned the redactions, and you did use the word excessive redaction. I was wondering if you could elaborate further on when does redaction become excessive, and how does it relate to fees? Although, if there aren't that many fees being charged, then it wouldn't make that big a difference. But it would definitely takes a difference in time of getting records, even at the federal request. I'd just like to understand that more. Is there ways to reduce redaction? Is there a sense that either you, Margaret, or Tom have about when it crosses over into excessive, and how does that relate to the efficiency of balancing that efficiency versus necessity of some things not being public record?
So in the first place, obviously, when I use the word redaction, the assumption is you're going to get something, because as opposed to denying any access. And I think the excessive redaction comes in when agencies simply read the exemptions too broadly, and for example, under personal privacy, we'll cross out the names of federal officials involved. Okay, or we have at the local level in DC, when we get police video cams, they blur out, from public places, they blur out, street signs, the officers' badges. I mean, and then charge a tremendous, that body cam videos is a big issue for us locally here, because, they use a contractor to do the redaction, and the contractor, every time there's a face on the street, I mean, and a lot of the cases are being brought now to get that information. They're coming into with social media, handheld camera, handheld telephone videos that were taken in the same place in the same time. to show that what privacy is involved in this. So I mean, I'm just using, you know, an example of, and then there's this refusal to provide any of the record because some of it might, well, you're supposed to segregate at the federal level, and it's statute specific. But you know, I've seen pages that documents of multiple pages where the only thing you get is a header, and they simply black out the rest. So I mean, that's what I think it's simply overuse of the exemptions to block public disclosure.
Margaret, do you have anything to add to that?
Oh, no, I totally agree on all those fronts. I guess the only other thing I would say is, to the extent that you're trying to think about alternatives to individual requests, things like proactive disclosure, a lot of times agencies will resist on the grounds that, well, then we'd have to review this whole category of records line by line before we post them. A lot of times, if you dig beneath the surface of that pushback, you can see that, you know, these standard forms, these standard kinds of reports could be, with very minimal effort, redesigned to make sure that the stuff that can't be released is always in one box, or always on one line, or always, you know, in a place. People have talked about this. I think actually Ginger was the first one who used this word with me, transparency by design. And I think it means that we have to think about making things releasable when we create them. And then it's not burdensome to say, publish the whole data set, because we know that box E always is blacked out, or whatever it is, you know.
Todd, thank you. Thank you, Todd.
Make sure I'm actually unmuted first. Thank you. Again, thank you to both of you. This has been incredibly illuminating for me, maybe in part because, as much as it troubles me that these issues also exist at the federal level, I'm kind of heartened that they do, because it's good to know that sort of Oregon's problems in some ways are universal and are being thought of in a lot of the same ways across the country. A lot of what I heard here are things that we have addressed or discussed or kicked around, or that I talk about in my trainings to public bodies on best practices. So it's good to know we're not alone. It's good to know we're sort of moving in the right direction, and there's possibly hope here. But what I really wanted to ask both of you was your opinion on, since we're focused on fee reform right now in the subcommittee and are considering specifically how to shift some of the burden of pain for this system from requesters maybe back onto the public bodies or government, like writ large, however you want to think about it. What I think I'm hearing is that we can't really just focus on fee reform, that if we want this to work, that it needs to sort of be coupled with other changes or other sort of requirements like reporting, proactive disclosure, what have you. And if you had sort of like a top three, maybe, if that's fair to ask, to what you think needs to be included, must be included with fee reform, I'd really love to hear it. I promise I won't hold you to it. But just generally, if you had a holistic sort of magic wand to fix quote unquote fees, what other prongs would go along with that? And you only have 5 minutes to answer.
I'm gonna interrupt Todd here and say the top 5, because I think top 3 short shrifts the issue, because I think this is a lot more complex than we're, you know, going into this. I thought we were just talking about fees. It's clearly not going to be just about fees, I think, folks. So I'd welcome those top 5, even though Todd said 3.
And I, as a chair, I'm just going to interject in that too, that we've had discussions about whether we're talking about fees or whether we're talking about costs and the cost of providing information in a democracy. And we've really tried to frame it that way, that it's not just a transaction, it's more of a, I don't know, is commitment the right word? Anyway, so with that said, we'd love to hear your 5, or yeah.
So I want to go first because Margaret will have 5 and I don't have any. My proposal is have the agency have require by law that the agency identify the, you know, largest number or most expensive or whatever, you know, area of requests, categories of requests. And so that's, and then pick one each year to come up with an alternative approach that streamlines disclosure, or, you know, something that, because it's very hard from the outside to say immigration is a perfect thing, because you would think that screams for reform. And the advisory committee that I'm on, we met with the Homeland Security people, and they absolutely resisted it. One of the head FOIA person in Homeland Security used to head the Office of Open Government in Washington, the Office of Government Information Services, a very enlightened, very knowledgeable, experienced guy. And he said, these hundreds of people we have moving pallets of documents in underground storage facilities to come up with the A1 file that's the way we have to do it because, there's some classified stuff, there's some criminal stuff. The Congress has said we have to keep this in paper for, 47 different reasons why they can't do anything. And so, as an advisory committee, we didn't feel our approach was not to tell them how to do it, but to say, okay, we suggest that you bring in MITRE that works with classified information and has done FOIA reports from outside to come in, and Congress provide funding for an outside study, and think of what could be saved if you can get that under control. And so identifying it, step one, figuring out what to do about it, I don't know, is something that I didn't feel, and those of us working in this area haven't yet figured out what the answer should be. So now, but Margaret knows the answer.
I don't know the answer. I'm trying to figure out if I can come up with 5. So I will say I've heard lots of, I don't know much about Oregon to begin with. So I think it's just something, just full disclosure. I've heard lots of reports across the country from state laws where excessive fees are a huge problem for journalists. And so I think tackling that issue is important. It's important in its own right. And if you do nothing more but make fees waived or low or no entry barrier for journalists, you will have done something important. And you can do that alone without necessarily fixing all else that is broken, though I think it's worthy of thinking about whether there's opportunities to use that reform to pair with other things. So what would the other things be? I think some amount of state level funding stream that goes to local entities to do this work so that it is possible, right, to meet these obligations. I just don't see how else it can happen, or that this that individuals with these responsibilities can in fact professionalize and get the professional development and training, have the expertise to carry out these obligations and the time necessary. So I'd say funding actually goes nicely with fees. Like those are, it's both about money. So like if you're trying to find a bill, sometimes things that are all about money go together. The next things on my list, if I were coming up with like a dream list, would probably be actually, I would love it if, say, Oregon wanted to be on the leading edge of states in terms of tracking public records requests. If you included in the law that every public body had to track all the requests with a unique identifying number, as the federal law has a requirement in the statute that says that's what creates the FOIA log. Just you have to track every request. And then to report that data to, I don't know, like whoever makes sense in Oregon, the AG, somebody. And I think at that point you would know how many entities are performing these obligations, how many requests they're getting, how much it's really costing the agencies. You might have data that would support funding streams. You might get data about who all these requesters are and what records they need that would actually lend itself to solutions that would become obvious once you know. It's like transparency about the transparency system. I know it sounds sort of like meta, but I think it's actually worthwhile. I think having a state do something like that would actually make a huge difference for the country, because I don't think there's any state that knows who their requesters are. And it's probably not so dissimilar state to state. And if we started to know what state level requests look like, we might be able to start to think about reforms more sensibly. And then I guess my last thing would be, and this is probably just my own personal, I am an academic at a public institution. So I do think, so it's just, full disclosure there too. I do think there's a real academic freedom problem happening with that is butting heads with open records laws, and I'm not sure if that's happening in Oregon in particular, but it's, it's something that I think states are going to have to grapple with because I think it's an upward trend. So to the extent that, you know, legislatures are thinking about open records law reforms, I think we also need to start thinking about academic freedom. And I think we're starting to see evidence that we have to think about that down to K-12 education. Was that 5? I don't think so.
4, but who's counting? It was 4, but who's counting, right?
Thank you. Yeah. Oh boy, this has been really interesting. Thank you both very, very much. Steve, I wanted to also thank you for inviting Margaret and Tom and finding them. And I'm going to give another plug for your book. I'm enjoying it, and you can get it in the paperback, which I like to write down. It's got pencil marks in it, but it's also available as a digital product. I hope that we can reach out to you again with potential follow-up questions if we have them. I do just want to say thank you very much. Before everybody goes, I do want to run through, or I can stay on and just do it for the video, what was not recorded at the beginning of the meeting. So there is a public record of that. But we have about 1 minute, I guess, on my clock left. Does anybody have a final question at all, or for either of our guests, or we can reach out directly if we need to?
I just want to thank both of you for taking the time out of your busy schedules. This has been fantastic. I've really enjoyed this conversation, and obviously you folks are well steeped in these issues, and I greatly appreciate your giving your time to us so that we can at least get a better understanding of this area, because it has been a topic of question for me, and I suspect others, and this has really been wonderful. So thank you so much today for your time and your patience with me in particular, Margaret.
Steve, did you want to say something? Mm-hmm. No.
Yeah, sorry, not to drag this out too much, but I just want to see if there were any of our guests on the line who don't have access to the hand raising tool, who wanted to make comments, members of the public and so forth. Sounds like we're we've worn everyone out.
I cover, yeah, count to 30. That'd be okay. Thank you. That's a great. Thanks for that reminder, Steve.
Yep.
Okay. Well, anyone who needs to hop off, please feel free to do that. I'm going to, for the record, go through. Maybe we could keep a quorum here at least. Thank you, Margaret, and thank you, Tom.
Yes.
Just to go through what we talked about.
Thank you all for the invitation to be here. This was really a pleasure. It was a great discussion, and I'd welcome the chance to chat with any of you offline or at any point about these issues going forward. So take care.
And I look forward to learning how you resolve them. Bye.
We'll let you know. Thanks, Tom.
Appreciate it. Yeah,
thanks, Steve, for doing that. That was awesome, Steve.
Yeah, it was fun. I was really, I was, yeah, felt very fortunate they both had the time to give.
Yeah, good. I'm curious, actually, since we do still have a quorum here, Tyler and Mark, what was your initial kind of reaction to this, you know, like sort of micro solution as one thing, as sharing a public, sharing a records person? Does that even imaginable?
Yeah, do you want to go first, Mark? He's on mute.
Yeah, I know. I'm on mute. I really think it's going to be a challenge for the local government types to be able to share somebody like that. If I understand your question, Emily, you know, for me, I've got 950 special districts. Probably, I don't know, probably half of them haven't received a public records request in the last 4 years, you know. But at the same time, you know, I also have, for example, Tualatin Valley Fire and Rescue, which is the largest fire force in the entire state. And so I've got a real diversity of membership. I could certainly see it working, for example, potentially with school boards or entities that have perhaps a smaller membership. Here's the challenge, though, and you know, everybody has their own fiefdom, and I worry a little bit that there may be attorneys, let's just get right to it, who would be uncomfortable feeding that over to some other entity outside of their internal organization. If I'm understanding your question correctly, I'm not discounting this, don't get me wrong, but I think it would require a lot of talk, a lot of thinking, and I think a lot of bringing people along. Tyler, I don't know your reaction to it, but that's just my initial sense. I think it would be kind of difficult, maybe not impossible, but I do think that there are some fiefdoms that would have to be overcome at a minimum.
There it is. Todd just threw in the chat pilot program. I'm intrigued by that concept. I mean, I know at the county level, we often look for, you know, is there a way we could pool resources so that smaller counties could, you know, turn to a one-stop shop for sort of technical assistance for whatever it might be. I think that really gets to the meat of the issue, is that we have an incredibly diverse set of counties in Oregon, and we have incredibly diverse set of capabilities. I mean, to get back again to the kind of original sin of the revenue issue, we have permanent rates baked into our Constitution that are baked in the 90s, that and bear little to no reality to, you know, what timber harvests were, or a myriad of other things at the point when those rates were set. So what that means is that we do have counties that just simply are in even more of a cuts mindset all the time than others are. So to the extent that we can be efficient, share resources, yeah, I'm very, very intrigued by that concept. Yeah. But you know, I wrote down as the presenters were going through, I starred a couple of solutions that I would be really intrigued to dig in more on. One of them was about, you know, when you're requesting your own records, should you have I mean, that just seems like low-hanging fruit. That seems like something that if I went back to my members and said, that just seems like a basic function of government, that if somebody's requesting information about themselves, they should have access to that information. I'd be curious to pull that apart a little more. The idea of, let's look at transparency of designing transparency. Can we just start tracking requester types so that we have a better idea of what we're even talking about? I think that would help us avoid sort of sledgehammer solutions, or, you know, making an uninformed decision that leads to unintended consequences. That's something that could be at low cost, if not no cost, to, you know, if we standardize something where if it, you know, you get as a county clerk or the county council, when the public records request comes in, if you had at least the requester identifying, are you commercial, individual, we could at least start tracking that information and understanding who's seeking these records. That'd help us come up with solutions. And then, you know, I just continue to come back to the idea that we could just put even more explicitly into statute that if you have a narrow request, your fee gets reduced, because what we're encountering all the time is just these any and all type of requests. And I dropped into the chat a little earlier that recent, from 2 days ago, the Willamette Week article on police bureau requests, which are growing by 3% a year. There's an incredible backlog on them. I don't know to what extent, you know, seeking narrow requests is going to help that problem, but those are 3 ideas. And so to your original question, Emily, I'm very intrigued by the idea of how could we efficiently share resources? If there could be a one-stop shop, and if there were state funding involved to help the smallest of the small pay for it, that's a path I'm interested in discussing.
And I want to say I totally, you know, I totally sympathize with the stuckness of the local funding, but let's not try to tackle that one. Okay, because we won't get it. We won't get anywhere on it.
Yep. This is not a property tax reform work group. I understand. Yeah, Thank you.
But you have a lot of allies on that, so just, you know, down the road. Anyway, yeah, Todd and Steve, you both want to talk? Todd?
Yes, thanks. So first of all, I got to say, I was heartened by the fact that a lot of the solutions at the federal level come down to the thing that I say about 1 million times a day, which is communication between requesters and public bodies to try to get both sides to understand what is being sought, I think it's phenomenal that that's sort of like a key solution, because that's essentially humanizing this process, which in the end, that's really what it is, a conversation essentially between two people, like a member of the public, even if they're a member of the media, for which this request means a lot, and a public employee who's probably doing way too many things at once and like isn't getting paid enough for it, and like, you know, they're the person who lives and breathes this stuff every day. So I think it's huge that communication is sort of centered at all levels when it comes to dealing with transparency reform, and I love that. But to get back to what we were talking about a moment earlier about a solution, at least maybe at the local level, of maybe like sharing a records officer or something like that. You know, there are already some models in place that permit sort of like umbrella services that where each public body is not paying for like full FTEs on their own, like the assessments that everyone pays into DAS and you know, Government Ethics Commission. And so I think there really can be sort of this coupling of state level funding with each public body paying some sort of assessment based on their size or their reported levels of public records requests, where they are getting full services without having to pay full freight for it. And I think there's a lot of room here for us to do work and sort of come up with like long-term solutions that will build out the system. And yes, maybe we need to start with a pilot program. And I just want to remind this body that something we need to keep in mind is that the PRAC had a reporting bill that we put forth, but because of concerns by some of our local governments or representatives of our local government, it ultimately got winnowed down to merely being at the state level. And that was one of the reasons put forth by the governor's office and the legislature that it didn't succeed, because if the law applies to all public bodies in Oregon, so should reform. And so I think as we move forward, we need to keep that in mind, that any solution we come up with needs to probably, in order to work, affect all public bodies at the state and local level. And we can't like pull out pieces and want to get those into place and then maybe eventually come back to the others. And so we're going to have to revisit those concerns, which are always well expressed, but find ways to get through them, in my opinion, in order to get to a solution that will service everybody.
Yeah. Thanks. Steve, your hand is up next.
Well, a couple thoughts. I agree with, I think, everything that has just been said. I think, Tyler, on the self-request, I agree. Like, I think that would take care of a lot of stuff, because like looking back at the 2019 report, like the Oregon State Police made up 4,000 of those 22,000 records requests, and I bet you all of those are people asking for their own accident reports or their own crime report. And you mentioned the Portland Police Bureau backlog. I think it's the same deal there. It's not complex requests. It's just very simple, like my one report. And if they just figured out how, and I like what Tom says, like basically you say you need to, I mean, one carrot and stick you could think of is like, if you miss the deadline, if you have a backlog, then you have to pay, you have to eat the costs. And that would incentivize like figuring out how to fix that problem. Or you could just say, if it's for yourself, then it's automatically a fewer. I do think I think Tom mentioned this, like at the extremes, if you want to figure, it doesn't make sense to legislate for the extreme. Like I think we should legislate for the ordinary, like the most common requests, and then figure out how to deal with the extremes. And so if there's, I think if we had a system that made it the default, that the cost is going to be covered by government in some way, and then we could say, but there will be exceptions to that. Like at some level, it gets so extreme and crazy that it needs to get kicked into a different process. And I think that's what he's talking about with Connecticut. Like you could name some kind of threshold, or just say like unreasonable, and then it gets kicked over to Todd maybe, or somebody that like gets to decide, like, is this completely nuts?
That was really interesting, that Connecticut piece. I wasn't aware of that.
Yeah. Could we get I don't know, Todd, would it be possible for you to look into that little Connecticut model for us? Because that really, I have to confess, I put a star by that little note there, because I am intrigued by this, and I know that we've had a few not conversations, but sharing of articles where the bond issue, if you recall, where there's an organization out there going after school board employee bonds as a threat tactic towards, more politically motivated issues. We'll just leave it at that. I find that Connecticut example is being able to address a lot of what Steve just said, these extreme sort of weaponized requests that I continue to be concerned about. I've just never heard a solution, right?
Well,
I just heard a potential solution to that. And that really intrigues me. Not that it's a common instance, but it really could paralyze a very small and perhaps not greatly sophisticated entity in just paralyzing them. And that has happened. I know it's happened up in the state of Washington once. So, that intrigues me, and I'll just shut up at this point. The other thing I did. Go ahead.
I can answer you a little bit about the Freedom of Information Commission, or the Connecticut Freedom of Information Commission, because I have had occasion to cross paths with them at some ethics conferences where they've presented. And I have to say, it's an amazing, robust public body, but they are much larger, well-funded, and have certain mandatory enforcement authority that my office does not have. And so if kind of along the lines of things Ginger has discussed in the past during her tenure, is that if you want to increase what this office can do for the state and for requesters and for public bodies, we're going to have to take a hard look at our own funding, because the Connecticut Freedom of Information, and I'm not saying I'm opposed to it, I think it's a bad idea, but this Connecticut Freedom of Information Commission actually consists of two wings, one of which is an investigatory body that I believe can compel public bodies to turn over records and get guidance and opinions from them. And then there's an adjudicatory side that is a commission form with much more robust sort of enforcement capabilities, where you could essentially go to an administrative trial before them on public records matters. And it's an amazing institution that I've looked at in the past along the lines of thinking, well, can we ever grow an office in that direction? And when I go to the legislature in 23 for the office's own budget for the first time on my own, and might be asking for additional FTE, I might have some of this model in mind. But if we're going to go that route, this office definitely needs more funding, more staff, and honestly, more enforcement capability than what exists right now. But I would love having those discussions with all of you about what we'd want to ask for to make that happen, because I think it's something that could work in Oregon and could be of service to the public records community for sure.
Yeah, it intrigues me from the requester side, just in terms of acknowledging that does happen, certainly, but it's also becomes a myth in the narrative of what the problem is in public records. Like, as we've seen from the data, the vast majority aren't like nuisance or aren't, so it would, I think there'd be shared interests in creating some kind of mechanism to, not, as Steve said, legislate for the extreme, but have a open, public, transparent, rational process for handling things that we're bogging the system down in extreme ways. But also then, removing that from we'd have a solution for it. So it doesn't have to be the problem that's always waved around, that is the exception, which thwarts the debate toward getting actually anything done. We should probably wrap up. I've kept everybody much longer than we should have, but Steve, you did have your hand up. Would you like to, was there something you wanted to add?
I was just going to suggest, if I wouldn't, Todd, if you have familiarity with Connecticut, maybe we could put them on the agenda for testimony.
I'd be happy to reach out to them. And would the focus of the testimony be their experience adjudicating fee issues, or we wanted to hear about their structure?
I mean, I think we obviously probably want some broad overview of their structure, but like our task at hand, right? We are focused on this, on costs. So if you're picking one person from one of the sides, I would pick from that side. I would suggest that might be appropriate.
And I don't know whether or not the Connecticut model is something that we can necessarily take up as a function of trying to get something prepared, hopefully by September. That's an entirely another topic, and I'm very intrigued by it. You know, if there's a Todd, I do think that's probably a topic that we'll need to discuss more. That's a big ask, right? And my feeling right now is, just to be very transparent, is we're trying to get our feet on the ground and established. And I don't know if we want to take too big of a bite that we can't necessarily digest. That's my only cautionary sort of tale.
Steve?
I do think, though, that this discussion today especially has highlighted that we need us, and I don't think we should shy from talking about fiscal impact, potentially. You know, I mean, we conceivably we're early enough in the year that we could even have discussions with, you know, with DAS and the governor's office. You know, if we're thinking about, like, basically trying to, you know, make more transparent the costs and accept that there are costs and make sure that they're adequately supported, you know, rather than simply approving something that's essentially an unfunded mandate. I think we should be open to that discussion.
Yeah, I would agree. I do want to run through the top of the agenda so it's on the record and so we all remember, but is there anything else on this discussion, which has been really interesting and fruitful? Thank you all for sticking around to participate. Anybody else want to add anything right now? Okay, then let's just, you know, just for the record, we approved the agenda. Then we had some discussion about other people who are already scheduled to come up to testify, and some discussion of other types of people we'd like to see come and testify. And I'm going to ask all of you to help my memory here. I have some notes mostly on my own to-do list, but I'm going to look into getting someone from the Public Employees Union to come talk with us. I'm looking at probably the May 13th date. We agreed that we can, you know, mix and match types of witnesses. They don't all have to be on the same subject. I think Mark was going to look into people from some of the districts that you represent, maybe school, maybe some smaller districts. We had brought up the idea of hearing from people who take emergency calls. And I believe that was Mark or Todd was going to follow up on that. Todd's going to follow up on that. Okay.
And Todd, I can assist too, but I thought just you had a fresh meeting with them. I'd have to do extra legwork. It seems, if you're okay with that, I'm happy to do it.
Great. And then I'm going to follow up with Alpro to just see when they think they may be on, you know, ready to come back and share what they've learned with us. Anybody else have notes from that top 10 minutes of the meeting?
Somebody was going to check with Alpro, I think.
That was me. Yeah, I'm going to do that. Yeah, thank you, Steve. That's it.
Emily, I just wanted to say we didn't have Margaret Quokka's slides in advance, but I have them now, and I'll get them posted as written testimony for today's meeting as well.
Oh, that's great. Thank you for remembering that. And another note to self to add on the agenda comment time for people who can't raise their hand. That was really nice to see you do that, Steve. I think I'm ready for a motion to adjourn this meeting. Anybody have a second?
Second.
All in favor of adjourning this interesting meeting?
Aye.
Thank you.
Thanks.
Have a great weekend, everybody. I'll see you in
Bye-bye.
Bye.
Bye.
Bye. Thank you.
How do you leave Teams?